back, friends, to the channel Indian Law Perspective. Today we'll see very important provision of this criminal procedure code, that is section 438 of the crpc, which deals with this anticipatory bail. Friends, we'll see very briefly what is the procedure of filing, where is the appropriate code for its filing, and what are the grounds that court looks for granting anticipatory bail, and what are the condition, and then duration, and where the appeal lies, and what all needs to be done for cancellation. So this, whenever if the person commits any non-cognizable and non-bailable offense, then an anticipatory bail application can be filed, because there are high chances that a person, if he commits any cognizable and non-bailable offense, then the person apprehend arrest on accusation of a cognizable non-bailable offense. So even before filing an FIR, an application seeking anticipatory bail can be moved. So some things should be considered before filing an application for anticipatory bail, and these are if the fact of the case are very vague and there is no real threat of arrest. In that case, one should not go for this anticipatory bail application, and it is not advisable to file this anticipatory bail application if there are high chances of rejection, as the rejection of anticipatory bail indirectly creates pressure on police officer to make arrest. So these two things one should keep in mind before filing this non anticipatory bail application. Then where is the appropriate code? What is the appropriate code for filing this anticipatory bail? One code is session code and the other one is high court. We can go in high court for seeking anticipatory bail application, and other one is session code. Generally, the general practice that is followed is one should go in a session code, and if the session code rejects anticipatory bail, then only one should go in a high court. But in some special circumstances, like strike of advocate, closure of session court, or some danger of visiting in local court, in such situations, high court may allow the application of this anticipatory bail directly. Then what are the grounds for this anticipatory bail? Actually, grant of anticipatory bail is a discretionary power of the court. It is not as of a right we get that bail. It is a discretionary power. However, court are guided by various considerations, like what kind of nature of offense we have committed, and gravity of the accusation or offenses, then possibility of accused fleeing from justice, that also look for, and then apprehension of tampering of evidence or influencing of witnesses. Sometimes the evidence is tampered when one if the person who is accused is outside jail, and then in order to save himself, he might tamper some evidences. So or he might influence the witnesses. So for this reason, court may reject if the court apprehend that such thing may happen, then in that case anticipatory bail might be rejected. If the gravity of the offense is too high, in that case also our anticipatory bail application may not be allowed. Then what is the standard procedure that court follows while granting this anticipatory bail? Actually, there are some general guidelines for granting an anticipatory bail, which are laid down by this our Honorable Supreme Court. So there are two cases where these guidelines are laid down. One is Guru Baksha Singh CBR and others versus the state of Punjab 1980 AIR 1632, and the same is confirmed in a Siddharam Satlingappa Mhetre versus state of Maharashtra 2011 1 SAC 694. So this all about anticipatory bail. It's a brief procedure of filing appropriate court and what are the grounds the court sees while allowing this anticipatory bail application that we have seen. That's all for today. See you in the next video. Thank you.